Your wedding begins here. You've found your person. Now find your perfect place. Welcome to Marin County, where your love story meets its perfect setting. Exchange vows beneath ancient redwoods on a sun-kissed beach or overlooking the sparkling San Francisco Bay. Whether you're planning an intimate elopement or a grand affair, Marin offers the space and the spirit to make your wedding uniquely yours. Discover where forever begins at visitmarin.org and explore the weddings page for details.
This episode is sponsored by StoryLeads, the LinkedIn agency we each use separately to grow our brands. They're the team behind Monica's growth from about 500 followers to over 8,000 on LinkedIn, and they've helped me grow my presence significantly too. But it's not just followers. Our posts get real impressions that turn into referrals, new clients, and even speaking opportunities like podcasts and panels. Because the reality is, being a great lawyer doesn't matter if no one sees it. If you've got great stories, StoryLeads extracts them, turns them into content that actually sounds like you, and gets you seen by the exact people who can send you opportunities. Welcome back. So in 2023, a fourth-generation South Carolina lawyer named Alex Murdaugh was convicted of executing his wife and son at their family property. He was given 2 life sentences back-to-back. And 3 years later, the South Carolina Supreme Court just threw out the entire conviction, not because of new evidence, not because of bad lawyering, but because of the lady who walked the jury in and out of the courtroom every day. And that is what today's episode is all about. We are going to be talking about the Alex Murdaugh murder, trial, appeal, and now retrial. And we're going to get into all of it because as of the week that we're recording this, the Supreme Court in South Carolina has overturned the double homicide convictions in that case. And that's a really big deal. So let's talk a little bit about the underlying case and then jump into the appeal and kind of go from there.
Yeah. I mean, first of all, every time I think of this case, obviously there's this, I feel like every time we talk, there's a Netflix documentary. There's a Netflix documentary. And like, that's where my mind goes because that's where I first got exposed to this case personally. And I think they start off the whole thing by saying that they're prosecutors or former prosecutors. And I'm like,
Who's the Murdaugh is a former prosecutor? I didn't know that.
Yeah, I think so. I'm pretty sure he is.
Yeah, I didn't know that.
Like,
I know he's
ironic.
A fourth generation lawyer.
Yeah.
And he was a partner in a quite successful law firm. Well, maybe not as successful as people thought because of some of his behavior, which is really at the crux of all of this. He was a partner at PMPED, which is Peters, Murdaugh, Parker, Eltsroth, and Dietrich. And it's a powerhouse personal injury firm in Hampton County, South Carolina. He was a respected attorney, a well-known family man, a churchgoer. But he had a dark private life. He was suffering from an opioid addiction, and he was in the process of committing a whole series of financial crimes against his law firm and against the government. And so
I think also what's important too here is that this is like a small community. Like this is not like South Florida where it's like, you know, you're prestigious or like a good lawyer, you go to church, like all these things like they kind of mean something different when you're from a smaller town.
Well, when you learn about the background of this family, it certainly does because they got out of a lot of things in their past. There were multiple run-ins with law enforcement over the years, and they were able to get out of those issues because of who
their connections
they were and who their family were, who his father was in the community, who he was, and their relationship to the sheriffs. It's like, you know, all the movies where there's that relationship and they've got, you know, bad influence. They're able to be a bad influence on the thing. But at some point, that bad influence runs out.
Yeah.
And it ran out in this scenario where he is accused of killing both his wife and one of his sons. At the dog kennels on their property, at or around the dog kennels on their property, and it's in a heinous way. They're killed using 2 different guns. One's an AR-15 and one's a shotgun. So that tells you something that the person or persons that did this, if it let's say it's one person that did this, that person had to stop what they were doing and switch guns at some point, which is a very telling part about what they were doing and how they were behaving. But ultimately, murders both of these people. And the question obviously becomes, well, why would this guy do that? And what prosecutors try to paint in the first trial is a picture of Alex Murdaugh trying to create a chaotic situation to distract from what was happening with his other financial crimes. And the day that his family was murdered, he was confronted by the CFO of his law firm about misappropriating client funds and stealing client funds. And so there are all of these reasons that at least are given by the prosecution for why he does this. That's what the justification is, okay? Not that it was this, huge thought out premeditated thing, but there was some level of premeditation there because he decided to do this as a distraction from what was going on. That was what it was. And honestly, in a circumstantial case, you think about that argument on its face and it kind of sounds a little weak. And it doesn't sound like something that you may be able to persuade a jury to convict someone of a double homicide with those facts. But there are other facts and evidence in this case that led to him being the one that was arrested. There is recordings on one of the son's phones. There is pings from cell phone towers from Alex Murdaugh himself.
Yeah.
And then obviously his story about what happened to police didn't add up and didn't make sense. So
from what I remember too is that they were able to place him at the scene of the crime with the cell towers.
Correct. They were able to ping him to his location. He insisted for months that he was never at the kennels that night. And then that changed when they were able to get the cell phone data.
Exactly.
He himself is the one that calls 911 that night and reports the murders. But he reports them as he just discovered them after arriving from his mother's house.
It's so funny that like he's an attorney, an experienced one, and thought all this was a good idea.
Well, yeah.
Like, not only did you commit 2 murders of your family members, not a good idea.
Disgusting.
But, yeah. But like everything following that, like very poor decision making.
Yeah, not well planned at all. But you have to think about this.
That's true. He did get away with so much leading up to it.
Right, but he's also he's a drug addict.
Yeah.
And he's got other things that he's more concerned about, which is losing his, reputation as a lawyer because everything was falling apart. The game, the financial games that he was playing and the
being
laws
exposed.
Correct. The laws that he was breaking, it was all coming out. So he got to a point where he was at a breaking point.
Yeah.
And the way that he decided to handle it, some people run and flee the country. This guy said, I'm going to make a chaotic situation and try to, and kill my family and make it seem like somebody else did it. And if everybody thinks somebody else did it, then they're all going to feel bad for me and everyone's going to forget about my financial crimes. That's his, opiate addicted mind thinking that that's what would be.
And also probably the fact that he has gotten away with so much for so long that he was like, I can actually get away with this.
Right. Well, there's allegations at least that he helped his son, the one that's still currently living, get away with murder in the past. The son, there was a murder that occurred on a boat.
Yes.
And the son was involved and somehow was able to avoid
not only avoid
any prosecution, but avoid any prosecution for a murder, for a DUI, was able to avoid everything. So, it caught up with them. And then, so the government brings the case. The case itself is in South Carolina. There are the case goes to trial, as a lot of these types of cases do, and this was a 6-week-long trial.
This was back in 2023.
Right, and gavel to gavel, it was televised. So everybody got to tune in and watch the entire trial. I watched a lot of it when it was on, it was kind of amazing because, like I said, it's a very circumstantial case. There's no video of him doing it. There's certain things that don't line up and are not, you don't have that you would like to have in a case like this. But there was a lot of evidence that mattered, right? So I talked about, there was a video on the son, Paul, who was murdered, his phone from a time-stamped video
before he got killed.
From 8:44 p.m., and you can hear his father's voice unmistakably in the background.
And he was saying that he wasn't
before
even
his
there.
Estimated death, right?
Yeah, which contradicts his own statement.
Exactly right. Then you have the cell phone and the GPS data that placed him at the scene and tracked him after, including driving past the spot where his wife's phone was later thrown. There was over 12 hours of testimony about all the financial crimes that he committed. So fake accounts, stolen settlements. There was civil discovery issues that he was involved in. All that was coming out. Also, interestingly enough, and something that doesn't always happen in these cases, he took the stand himself, Alex Murdaugh. He admitted to his opioid addiction.
I would think that he would have to after all the damage he's caused, because you have to explain whenever there's an inconsistency with my client's statement because they chose to yap before. I'm like, you want to go to trial, you better get up in front of those people and explain why there's a discrepancy.
Right.
So, it's not really, ideal because you don't want the defendant to testify. You don't want the client to testify. But he fucked himself.
Think about it. This is a lawyer. He's a narcissistic asshole that's gotten away with all this stuff. I can take the stand. I can take this. You know what's amazing about that? I cross-examined a lawyer last week. And as I was preparing the cross-examination, I was thinking a lot about if I was ever cross-examined and how I would behave on the cross-examination and what I would try to, do to avoid certain answers and things. And I tried to put myself in that position, and I had a very hard time doing it. I couldn't put myself in that spot, because you don't know what type of lawyer you're going to get. You don't know if they're going to be grilling you or not. And I've also prepped enough witnesses over time that I know certain things that I would do, like that I tell them, whether it's behave the same way with me as you do opposing counsel, keep your answers short, don't try to be squirrely, don't try to,
over-explain anything.
Correct things. Yeah, let your lawyer fix those things. And so to see a lawyer take the stand in such a high-profile case and be subject to cross-examination, I think is really interesting. Yeah. Because he's got special knowledge on being in the other situation of him being the one that's asking the questions.
Yeah.
So he had special preparation for doing this, for taking the stand. And I still think that he doesn't help his case by taking the stand.
Yeah.
Because he admits to his opioid addiction. He admits to stealing money from the law firms.
He should, because there's evidence showing that.
Yeah, he admitted to lying to investigators about being at the kennel, and he denies the killings.
Of course.
So I don't think he does much to help himself by taking the stand.
Yeah. It's really to explain that he lied before.
It's to basically say,
and I'm not lying today.
I'm an opioid addict and I steal money, but I would never kill my family.
Exactly.
That's what he's trying to, he's trying to get some degree of sympathy from that, which you're not going to get. And nobody's going to be sympathetic.
No.
Which is an interesting thing, because I think that a lot of that is going to lead to, I would predict, a motion to change venue in the future.
I feel like that should have been
for the new trial.
Yeah, but I feel like it would have been appropriate for the first time. Too.
Yeah, but this time it's definitely going to be appropriate.
Yeah.
So anyways, on March 2nd, so he takes the stand. There's 6 weeks of testimony. March 2nd, 2023, he's found guilty on 2 counts of murder and 2 counts of possessing a firearm during a violent crime. The jury deliberated for under 3 hours. So 6 weeks of testimony, and they only took 3 hours to deliberate.
Yeah.
And the jury's deliberation is a huge factor in this case, and we're going to get into that in a minute. March 3rd, 2023, so the day after, he's sentenced by Judge Newman to 2 consecutive life sentences for what he did. So what happens after that? Well, one of the things I said was he took the stand and admitted to all his financial crimes. So now he's got to have to deal with those.
Right.
So in September of 2023, he takes a federal plea to 22 financial crimes. So including wire fraud, bank fraud, conspiracy, money laundering, and sentencing is delayed into 2024. In November of 2023, he takes a state plea to dozens of financial crimes, and he's given a 27-year sentence. So he's got this 27-year sentence locked in. That's done. He agreed to that. April of 2024 comes around. He's sentenced on the federal case to 40 years in prison and $8 million in restitution. Okay. So bottom line for our listeners and for anybody else paying attention to this story, he's never getting out of jail.
Yeah.
Regardless of what happens with the murder case ultimately, even if he's acquitted, which I don't think he will be, even if he is acquitted, he's still going to be in jail for the rest of his life because of these other cases.
Yeah.
All right. So what happened to the murder case? Well, in comes the clerk, Becky Hill.
Well, and for purposes of Florida practitioners or people who are exposed to Florida courts, I should say, this clerk that we're referring to is someone that would operate as a deputy in our courtroom that would make sure that the court is in order, takes the jury in and out, instructs them, gathers all the evidence and gives it to them. Like, this is the person that operates as like the courtroom officer. It's
weird to me that it wouldn't be some sort of law enforcement or a bailiff or something like that, because the jury, there should be a sense of protecting the jury.
Yeah.
And
especially in criminal cases.
Right. And a clerk just doesn't seem like necessarily the appropriate person.
Unless they just call them that and they are a law enforcement officer. But
well, at least in this one, she was a county clerk of court.
Yeah.
And her official duties, Becky Hill, she was responsible for managing the jury, the evidence room, courtroom logistics, day to day. She was the closest authority figure the jurors interacted with for 6 straight weeks. Yeah. Okay. What else was she doing at this time? Well, she wanted her 15 minutes of fame, so she was writing a book.
On Alex Murdaugh.
And she wrote a book she co-authored a book called Behind the Doors of Justice, The Murdaugh Murders. She co-authored it with Neil Gordon while the case was still active. However, in late 2023, they find out that she plagiarized 12 pages of that book from an article that was written by a BBC reporter, and the publisher of the book halted the publishing, and I guess the book is not published anymore.
Yeah.
Or will not be published.
Clearly, she's willing to lie to get to her goals.
Well, yeah. I mean, but that's not all that she was doing.
Yeah.
The problem is that, okay, writing the book on its own, probably not that big of a deal. While it's going on that she's taking notes or doing something in her private world about it, maybe not that big of a deal. Okay. I'm just giving the benefit of the doubt there. But what is a very big deal is what the jurors wind up telling Murdaugh's lawyers after the case, because they start telling what Becky Hill was doing directly to them and during her interactions.
And this is over the course of 6 weeks.
Correct. She was saying things like, watch his actions, watch him closely during Murdaugh's direct testimony. She said, don't be fooled by the defense evidence. She said, this shouldn't take too long as jury deliberations began. And those quotes that I just read out, those are from juror sworn affidavits to the Murdaugh's lawyers telling them what they experienced during their period of deliberation. Juror Z specifically said that Hill's comments made it seem like he was already guilty, that Murdaugh was already guilty. So this guy is not being given a fair jury.
Yeah.
Because there is a person that is supposed to be basically invisible and is influencing the jury. So the Murdaugh's lawyers file an appeal in the case. And initially, there is, at the first appeal, it is the case is not overturned. So it makes its way to the Supreme Court in South Carolina. And there's an issue because there is something called a Remmer hearing that was supposed to occur and that didn't. And that's part of the basis for why things get overturned. I imagine people that are listening can kind of already sense where this is all going because it's very obvious what Becky Hill's conduct led to the case being overturned. But what was the court supposed to do? So under Remmer versus United States, any private communication or contact between a third party and a juror about the matter pending before the jury is presumptively prejudicial. So once the defense shows that that kind of contact happened, the burden flips to the state to prove that the contact was harmless. So the burden goes to the state to prove that the contact that Becky Hill had with the jury was harmless. And that's not something that they'd be able to do. So
it's not even that they're evaluating if there was contact at that point. Was this contact or whatever the substance of her communications was with you, did it affect your mindset in the jury? And you already said that there was a sworn testimony saying that's
what
exactly happened.
Exactly what happened, right. So during the initial appeal, retired Supreme Court Chief Justice Jean Toll found that as a matter of law, that Becky Hill did make improper comments to the jury and that Hill herself was not credible. But they denied a new trial motion concluding that the comments did not actually influence the verdict because they're saying that there's no proof that the comments impacted the jury's decision. But that's not what the proper test is. The proper test says that presumptively that was wrong.
And the state has to disprove.
The state has to now prove that wasn't the case. And that's not what happened in that appeal. So this set up that appeal to be
heard by the Florida
and to be heard by the Supreme Court right? in South Carolina.
I said Florida.
So the defense argued that the judge during that appeal misapplied the Remmer standard because once you find improper conduct, the burden flips to the state. So speculating about whether jurors were swayed is not the test. And that's what that judge was doing. The judge was just basically saying, I don't think the verdict was impacted because of Hill. There was enough evidence there that they would have convicted him. But that's not what the test is. And that's what set this whole thing up.
And then she was ultimately also prosecuted for it and took a plea.
Well, correct. Correct. And so in May of 2025, a grand jury in the state of South Carolina indicted Becky Hill on perjury, obstruction of justice, and misconduct in office. And the allegations included that she was providing access to sealed evidence. Photographs, everything else, graphic photographs about the Murdaugh murder. She was exposing to people that should not have had access to it. She lied under oath.
Sounds like she was taking the evidence home, for her book.
For her book, because she wanted to be famous.
Yeah.
And she ultimately pleads guilty to all counts, and she's given 3 years in probation. She's not sentenced to any prison time. She's just given probation.
And that's when the Supreme Court is reviewing.
And by the time the Supreme Court hears this, there's no way they can say she's credible because she just pled guilty to perjury.
On this exact case.
It doesn't matter. Yes, but it doesn't matter. Yeah. She pled guilty to perjury. She's not going to be somebody that they can trust as a source. So then that brings us to May 13th, 2026, where the Supreme Court in South Carolina 5-0 unanimous reversal and a new trial is ordered. And the justices are very clear with why they are overturning this double homicide conviction.
Yeah. And I just love this part of the opinion that I have here. Hill placed her fingers on the scales of justice, thereby denying Murdaugh his right to a fair trial by an impartial jury. And I think that is a really great summary of why this case was reversed, despite him being, all the things that we called him earlier in the episode. We still believe, obviously, that people deserve a right to a fair trial.
Absolutely.
And if you're going to get convicted and get 2 life sentences, it shouldn't be because,
there shouldn't be an air of jury tampering.
Yeah.
In a situation, in any situation. There needs to be a fair jury. And even in a case like this, where the majority of people that you speak to and the general consensus is that he is guilty of this crime, you are still entitled to a fair jury. And that's not what he got.
Well, what's interesting to me is, like, after hearing all of this, that the jurors themselves, like, came forward and were willing to talk to but for their, like, them going to defense and saying, hey, this is what happened. And that's not something that, like, jurors usually would do.
Right.
Like, I think they know the repercussions of something like that. So they probably felt like something was wrong while it was happening and felt like uncomfortable during the process because this is the person they're dealing with all day, every day. They're not talking, just like you said, this is literally the closest courtroom extension that they're getting because they're literally interacting with this individual in and out of the courtroom. So, like, having that exposure all day, and they're probably, like, the first time they heard that, they were probably like, I don't know, but, like, what do you do when you're a juror in that situation? So, like, I'm just thinking, like, props to those jurors that came forward and were like, this isn't right, even if they were the ones that actually convicted him and were like, these things were said to us. I
think what they should have done is passed a note to the judge and said this and saved the time for all this stuff because there wouldn't need to be all the appeals. They would have declared a mistrial and then the state could have just retried the case and it would have saved a lot of time and money for everybody.
I know, but, like, think about, like, first of all, as a jury, you don't really know that, but, like, also, like, they're probably thinking, like, okay, if I pass this note to the judge, I have to hand it to the person that I'm literally talking about. That's gonna
they're gonna look at the note.
And yeah, they may look at it. Even if they don't look at it, this is all gonna be aired out in front of them. And then, like, am I gonna be the person that sent the note to the judge in front of everybody? Like, I can just understand why it was never said amidst the 6 weeks, but obviously, as practitioners, we know how, like, things play out, and, like, it definitely would have saved so much time, energy, and resources. But
for sure,
the fact that they even came forward even after, I'm like, that's pretty cool. That doesn't happen.
No, I agree. And I think one of the things that I've benefited from in the course of my career is being able to talk to jurors after cases. And I've heard great feedback from jurors after. And that's, jurors don't have to talk to you after, but I, as a prosecutor and as a defense attorney, have had the privilege of talking to jurors after cases, and you get a lot of good information, a lot of good feedback about yourself, about the case, about whatever. But that's not something you get during the trial.
No.
And you don't. You're
not even allowed to look at them.
You don't talk.
You're not allowed to, like,
you don't have improper contact with them.
None.
You just don't. There's no reason to do that.
It's almost uncomfortable how much contact you're not allowed to have with the jurors as the trial lawyer on the case. Like, you literally can't look in their direction because, like, if they see you, like, I don't know, I always worry. It's like, I'm a smiley person. I don't want to, I'm smiling and say hi to someone in the courthouse and I turn around, there's a juror in my case. Like, I just, like, feel like I need to, like, wait for everybody to get out of the building for me to be out and about in the hallways. Cause I'm like, this is, like, I know almost everybody here, especially in Palm Beach County. Like, I'm just, like, in and out, So I'm like, nobody look at me.
I'm
paranoid.
I'm not.
You're like, I don't do any of that.
I don't do any of that. Like, I'm like,
this is another day.
These are other people.
Yeah.
There's other people standing in the room with me.
Nobody look at me or touch.
Yeah, right. You want to try the case behind one of those, like, screens where they can't see who you are.
Like, or with a mask on.
Right. Oh, man.
But this is also, like, I think because it's so fresh and new, like, a lot of people are probably going to be talking about, the retrial and how the state will, the
state already said they will.
I was going to say, I don't know why they wouldn't, considering, like, it's
a double homicide. You got, and it's the most high profile case in South Carolina in a long time.
Yeah.
And, there's no way you don't retry it. But here's something that's pretty interesting. The Supreme Court, when they overturned the case, they did it on 2 grounds. The first was the jury interference, which we've been talking about, and that the appellate judge below the Supreme Court misapplied the Remmer standard. That we understand. But here's an interesting thing that's going to really have an impact on the second case. The second ground that the Supreme Court in South Carolina found to overturn the Murdaugh case was that the court agreed that the financial fraud was relevant to motive. So they agreed that Murdaugh's other financial crimes that he was involved in at the time did play a role in his motive, because that's what the state was saying. The motive was to try to make a distraction from what was going on with all these cases. But the Supreme Court also said that the trial court allowed the state to go too far and too deep into the financial crime stuff, because they were saying it's uncharged financial conduct, and it was turning the murder trial into an attack more on his character than on the facts of the case. Well, but here's something very interesting now. They're going to retry this case. What's happened since they tried it?
He's been convicted.
So now I don't see why they have a problem. You think they can't bring it up because he was convicted after?
They can bring up, if he testifies, they can bring it up as, something that to attack his credibility, just as a conviction of a
crime of dishonesty.
Crime of dishonesty, correct.
Okay.
And it's, how many counts. So that alone can be brought in, like you've been convicted of 40, whatever, let's say, I don't know how many counts, but like 42 counts of fraud. That's one situation. But to get into the facts regarding the motive, I think will be limited in showing the motive only for purposes of that. I don't think they're going to be able to get into I think like the CFO conversation and like things like that may be able to come in, but I don't think they're going to be able to get into the depth of like maybe even like the amount of money, like even something like that. Because just as a defense attorney, anytime there's an uncharged crime or a crime that it's usually an uncharged crime that is a bad act that's involved in the case. And this can come up in like situations where my client is charged with one count of battery and they smack someone and spat on them. I'm like, okay, which one? It's uncharged crime. One of them's uncharged. Unless it meets the exception that's like, whatever, it's one, there's like, if it's a part of one act, then it's like fine to come in. But if they're separated acts, you cannot do that. You cannot talk about an uncharged crime in a trial where you're trying the defendant, just like P. Diddy's case, where I think that showing the video of the domestic was an uncharged crime. I think that was the same situation of the like 404. I think that's showing bad character evidence unless you're able to show that it's a part of a grander scheme, modus operandi, motive, intent, all those things, which are the exceptions to this. And also same thing with Weinstein, which we'll talk about. But this is a common occurrence in a lot of criminal cases, and especially when it comes to like whatever, P. Diddy, Weinstein, Epstein, when it comes to people who have a lot of patterns, it's easier to show that stuff as long as it fits that pattern. But with P. Diddy in that instance that I'm talking about, it was a domestic violence incident which was isolated from what he was accused of, which was RICO. Right. So all that to say that I think they would be able to get into it, but I just think it would be very limited and for certain purposes.
I think you're right. I think that the state can say, the reason that he committed these heinous crimes was because he wanted to distract from financial crimes that were being committed. You don't really need to do a deeper dive than that. You don't need to get up there and say, financial crime 1, 10 million from this person, financial crime 2, 40 million from this. I don't think you need to do that. And I think doing that is exactly what this court pointed out as is improper. But what creates challenges now is these are no longer uncharged crimes. They're all crimes that he's taken pleas to. So how does the defense can't get up there and say that's not a thing anymore? The defense has got to be careful the way they argue that isn't his motive, or because their argument is he didn't do this. So they're going to get up there and say, yes, he committed financial crimes that are not related to this. Yes, he was an opiate addict, but those are not reasons to kill your family, and that's not the reason that he did.
And I think
that's all they can. That's really all they can.
That's the factual argument to the jury, but I think to limit the scope of what comes in before the jury when you're making legal arguments to the judge or the court, you have to break the nexus of showing that there's probative value to that motive or to that financial crime to show motive. So you really have to, and which is a low bar. Like we know that relevance is very easy to show, but they would still have to tie it to the motive. So if they're, if it's extra, if it's extra stuff that's coming in and they have another way of proving that motive, then, it should be limited. And that's why I think the court's ruling is that it can come in for purposes of showing the motive, but you cannot just let it all come in.
Right. It can't be a trial on those crimes.
Basically.
And that's not what the focus is.
Exactly.
But it is important for them because it goes to the heart of their motive argument.
Yeah. Which is context to the crime, to that crime that he's being charged with.
Correct.
So that's a super important legal issue that
likely the actual motive of the case, because when you really go into this and you break it down, there is not really a whole lot of other motive in the case.
Yeah.
There's nothing else that was going on that we learned about with the family. Now, his wife wasn't cheating on him and he found out about it. That wasn't what was going on here.
Yeah.
So there really isn't a whole lot of other motive other than his private activities were coming to light and became problematic and became, led him to want to do something to distract from those issues.
Yeah.
Because his world around him was crumbling.
I can't believe that. It's like that's where your mind goes.
Right.
When you have resources and you can run away.
Right. Well, who knows how much money he actually had?
True.
And a lot of that money is now, whatever money he had is going to go in criminal restitution. So what's really interesting, and I heard this on the news the other day, his criminal defense attorneys are not getting paid for the new trial. So they are going to try to figure out other avenues of collecting money. No. They're still going to represent him. They're going to see it through. But they got paid on the first trial. They said that the costs alone for the defense in the first trial were $600,000.
I believe that.
So I don't know what they're gonna.
I'm like, wait, hold on. Costs?
Their costs were $600,000. I have no idea what that.
No, I don't believe that. Actually,
that's what they said on his lawyers. That's a verbatim quote.
That's so crazy.
So I don't know what they were spent. Whether it was experts, depots, transcripts,
$600K,
people to review evidence, investigators.
Okay.
Crime scene analysts, whatever. That's what they were.
Yeah, there's the difference for people who don't know. A difference between legal costs and legal fees. Legal fees are what pay us. Legal costs is what pays for costs associated with your case. Like if we need to take a depo, you're paying for that depo, which is usually like, I don't know, fucking $100, $150.
And with the transcript.
With everything, like everything included. Like
right. So there's
so
the amount of money that went just in costs.
That's crazy.
Because you have to imagine they hired a lot of investigators that probably investigated the case and were like, no, you guys are fucked. Yeah. And then you're like, and then you're like, oh, I'm not going to use that investigator at trial that's telling me that we're screwed.
Let me get another one.
So let me find another. Right. So that's probably what,
that is so
where
crazy.
some of the costs went. But it's very interesting because they're high profile lawyers that he has. And they're going to basically take on another potentially 6-week trial with not getting paid.
That's going to be very exhausting, I'm sure, for them. And especially knowing probably what the result will be. But listen, they put up a good fight the first time. They may get something the second time.
I'll tell you right now, as a prosecutor, there was nothing easier than retrying a case. I thought retrials were so easy. And one of the questions that gets raised is, yeah, but now the defense knows everything that you're going to do. Well, yeah, but the defense is also locked into a lot of shit now because they got testimony that they gave. Right. So they're locked in. So what's he going to do? He's going to get up there on the stand. He's not going to remember verbatim what he said. No. So he's going to get impeached and he's going to look like a liar.
He's going to get impeached twice.
Right. And that's That's it.
I mean,
so once he gets impeached, I mean,
not take the stand this time. He should just sit his ass down.
Well, I feel like they're not going to resolve it with like an offer before trial or anything. So it's not like it would.
They may. You never know.
He's not going to take I don't think he takes a life plea in both cases. Yeah. What are they going to offer him?
They could offer him 40 years.
What, to run concurrent with his federal sentence?
This man's going to die in prison.
No, he is dying in prison.
So literally doesn't matter. But
it matters what they if they were to resolve the case with a plea, it matters what that plea is for. They can't give him a 15 years, a 15-year plea.
Yeah.
Like they've got it. Because of how egregious the situation is.
Yeah.
They've got to give him something commensurate, and that's only going to be like either a life sentence or something equivalent to life, 50 years per count, something like that.
Yeah.
But I don't think he will admit to doing this. I don't think he'll ever admit to doing it. So I don't think there would be a plea. I think
you're probably right, actually.
I think that it's past the point of
I bet if his legal team was like, you got to pay up, he'll be like...
I don't think he cares. I don't think he's got any more money. I think he's tried.
Yeah.
Because all his money that first off, he was stealing tons of money. That was what he was stealing the money because he didn't have the money to begin with because he was spending all his money on drugs. And so what little resources or assets he has, all are, I'm sure, going to pay back the money that he took.
Yeah.
He's got restitution, I'm sure,
$8 million.
That's just in one case.
Yeah.
So I'm sure he's got restitution in the state case also. So, he's got no assets anymore.
No. Yeah, he's done for it.
Yeah.
And I mean, when it comes to having and this is something that we say just like as attorneys when we're litigating is like the bell cannot be unrung. Is like there are certain things we can come back from and like certain things we can't. And like there are certain legal issues that just when they happen in trial, like you were saying, the time for the jurors to say something would have been in the middle of the trial and not after. But like those are just examples. Like these are examples when it comes to like reversals and like trials coming back and like having to redo it from the beginning to end. You just can't. Certain things you just can't recover from. And so you have to start over. Unfortunately, that's like the only real solution to the issue. So the other thing I wanted to mention is that because the way you laid out the facts in the beginning was really good. And I was like, the way I hope the state, if they did a good job, would have laid it out the way you did with like the timeline of things and like placing him at the scene of the murder despite his statements. And I feel like even though it's circumstantial, it is a very strong circumstantial case. It's not one of the cases where, like we talked about in other cases like Casey Anthony, where it's like super circumstantial, but there are other explanations that are reasonable.
Right. They got evidence putting him there.
Yeah.
That's different than just your plain circumstantial case.
Right.
This is two pieces of evidence, the GPS from his phone and the video from his son's phone, that definitely put him, A, somewhere he said he wasn't, and B, the scene of the crime. So I think that's the best evidence that the state has, is to be able to say the GPS and the video on the son's phone put him there. There's no way around that.
Yeah. And throw in everything else when it comes to like his motive and everything. But yeah, so this all just happened this week, the reversal, and, we'll wait and see what happens later in 2026 on the retrial. But
what's really amazing is also, you talk about the way that criminal cases work and the timelines on criminal cases. I started off the episode by saying the date of his conviction. The actual murders happened in 2021. So these cases have been going on for a long time, and we're just getting back to the trial footing because of the reversal on appeal. So, the cases take time to bring, they take time to challenge, and they take a significant amount of time to prepare. And the defense team is now going to have a lot of questions to answer. One of those big questions is whether or not you put him on the stand again.
Yeah.
I don't know if you do.
I don't know either.
I don't see the benefit in doing that the second time. And if you don't do that, it just leaves the jury with the obvious question of why did he lie about being there? And that's it. and they're not going to get an answer to that. There's no way a jury sees the evidence and goes, "Oh, I'm not convicting."
Yeah.
That's not reasonable doubt.
Exactly.
So,
I feel like it would only make the situation worse for the defense if he does get on the stand, for sure.
Yeah, I don't see it benefiting him, especially the second time.
Yeah, I agree.
Even if you take away the fact that he's now been convicted of all the financial crimes, he's locked into all the answers he gave, and there's just no way he's smart enough to remember everything he said verbatim while he's on the stand being grilled by somebody. It's just...
I mean, I always get, whenever that's the situation with my clients, I always order the transcripts and have them review it before, and I'm like, read this and memorize it and know it. Obviously, it's not the situation always, but sometimes it works. But he doesn't seem like someone that can even stay consistent, even just like as an attorney, like to know that you can be impeached. Like, you know this.
You know why? Because he's not telling the truth.
Yeah.
And it is also very easy to keep your shit together when you're telling the truth. It's a lot harder when you're lying.
Yeah. Yeah.
Even the best narcissist lawyer is still not going to be the perfect, taking the stand. A lawyer taking the stand is not going to be, just because they're a lawyer doesn't mean that them taking the stand changes the
game for them.
Right. And they are subject to the same type of cross-examination.
I know. I'm just saying that because I'm like, you should just know that it will be used against you. Like, why do you think that you're smarter than the situation is really my question. But
because
obviously
just like
he's a
you
narcissist.
said, he got away with all this stuff in the past, and that's,
Must be nice. No, I'm just kidding. Well,
but yeah.
Anything else?
No, me either.
So if you like listening to the show, make sure you like, comment, and subscribe. We're on all platforms. Come back with a warrant.pod. Leave us a 5-star review and make sure you subscribe to our newsletter. And if you didn't like listening to us,
come back with a warrant. If you're a lawyer sitting on great stories but not sharing them, you're leaving opportunities on the table. Story Leads has worked with over 100 attorneys, written more than 8,000 LinkedIn posts for lawyers, and helped drive over $35 million in case value from LinkedIn referrals. Being a great lawyer doesn't matter if no one sees it, and Story Leads helps make sure they do. Make sure you check them out in the show notes.
Your wedding begins here. You've found your person. Now find your perfect place. Welcome to Marin County, where your love story meets its perfect setting. Exchange vows beneath ancient redwoods on a sun-kissed beach or overlooking the sparkling San Francisco Bay. Whether you're planning an intimate elopement or a grand affair, Marin offers the space and the spirit to make your wedding uniquely yours. Discover where forever begins at visitmarin.org and explore the weddings page for details.